Session, which is the important hatches the egg book that we're going to read, and then there'll be a session on ethics and genetics. I think that's 11 topics basically, and that the last thing that we'll cover on the test will be ethics and genetics. Okay, and then the rest of the material will be covered on the second exam. All right. There's also a debate. If you look at this, if you look at the schedule, and the debate is 10% of your grade, so that'll take place in the second half of the course. So today we're going to talk. Yeah, go ahead.
Should we supplement our studies with the book as well as the PowerPoint? Would you recommend
the test?
Yeah, book and PowerPoint. Or
yeah, I mean, I wouldn't consider it supplementation. I mean, the syllabus says that you're supposed to read this assigned chapter. So yes, you should do that. And if you're directed to do anything else, either in the syllabus or in the slides, if the slides, for example, direct you to a certain website, then that's fair game. So you should make sure you do that as well. All right, I'm just going to show a brief clip because today's topic is confidentiality, so it illustrates the importance of keeping secrets. It's only about 5 minutes. You guys might enjoy it, so.
Remember me promising you I was going to get 2 tickets to take you to a real Broadway show?
Yeah, I remember. That was Thursday, August the 5th, 1942.
Well, I'm keeping my promise, Alice. There they are. 2 tickets to Murder Strikes Out.
Oh.
The boss, he can't use them, so he gave them to me. He says, go ahead.
Murder Strikes Out. I heard about that show. That's the show that's supposed to keep you in thrills, chills, and suspense for over 3 hours.
It's a big hit. You saw the advertisements in the paper, don't tell anybody what the ending is, keep the ending a surprise.
Oh, Ralph, how wonderful.
Can you hear it?
Wait to see it.
Well, look, go in and get dressed, and right after the show, we'll go to the Hong Kong Gardens. We'll make a whole night of the thing.
Ralph, you mean the tickets are for the night?
Yeah.
My mother's coming tonight. She'll be here any minute. I can't go. It's impossible.
You're not going to stand there and tell me, Alice, that you're going to spoil my evening and your evening and both of our chances to see a Broadway show because your mother is coming. You're not going to tell me that, are you, Alice?
Ralph, I don't want to spoil your evening, but I don't want to disappoint my mother. She's coming all the way from Bensonhurst.
That's a big deal. Where's Bensonhurst, the New Zealand or something?
Listen, Ralph, I am too tired to argue. My mother's coming and I can't go. Why don't you take Dawn? How about it, Ed? Would you like to see that show?
Well, I don't think I can. I only kept the video and video ranges around tonight.
You mean to tell me you're not going to take the chance to see a show like Murder Strikes Out? Instead, you want to watch Gatlin video and its video ranges? Now, come on, Norton. Do you want to go or don't you? I can't use 2 seats.
That's a matter of opinion. I managed to squeeze in somehow.
All right, go ahead and get dressed. Your mother. Your mother, I gotta waste the ticket on a junior space cadet.
Listen, Ralph, don't go blaming my mother. It is not her fault. How could she know that you have tickets to a show?
Oh, she knows. She knows. I don't know how she finds out, but she knows. I don't know whether she uses a Ouija board or a corn cellar, but she knows.
Listen, Ralph, I know Mother isn't the easiest person in this world to get along with, but that's no reason for you to act the way you do.
I act the way I do, Alice, because your mother is a blabbermouth. A blabbermouth.
Ralph, I have told you about that before. I don't want your calling her that.
All right. You're an expert at crossword puzzles. Give me another word for blabbermouth. As soon as she come in here, she starts in talking. The minute she steps in till the minute she steps out, she starts in on me. Oh, if Alice only had married those other boyfriends. Oh, Ralph, I eat so much. You're so fat. Yeah, why don't you get some furniture for the apartment? Your mother's nosy, Alice. Nosy. Snooping around. Anything I hate is a nosy blabbermouth.
Now, listen, Ralph, I am warning you for the last time. You call her that once more, and when my mother leaves here tonight, I just might go with her.
All right, I won't say a word. I won't say a word to you or to your mother.
That'll suit me just fine. At least that way there won't be any argument.
There won't be any argument. You think because I don't say a word there won't be an argument? Are you kidding? I'll bet you $1 million that she won't be in this apartment 3 minutes before she starts an argument. I won't have to say a word, Alice. 3 minutes, I guess. She'll start an argument. Without a word from me.
Oh, Alice, dear. Oh, dear. I'm glad to sit down. You know, I wish you didn't live so far from the subway.
Oh, Mother, it's only 3 blocks.
3 long blocks, but I suppose you can't do any better with the rest that you can afford. And your sister only lives a half a block from the subway. Well, that's one of the advantages of having a husband that's a good provider.
Mother, I have some coffee on. Would you like some?
Oh, that'd be nice, dear. Yes, thank you. Sam, you look fit. Are you getting enough to eat?
Oh. Well, of course I am, Mother. You wouldn't say that if you could see our food bill.
Well, I don't doubt the bills are high. But how much of the food are you getting?
Don't you worry about me. I feel just fine.
Well, I hope so. My goodness, a little food is the least you can get out of Mary. Oh! Oh, by the way. Yes, oh, Chester Barnes. Oh, you remember Chester, that nice boy that was so crazy about you.
Yeah, how is it?
Oh, he's fine. He's just fine. Oh, and he's handsome as an ever. Oh, my dear. And he's so tall, slim. I guess a man doesn't have to get fat if he doesn't want to. Oh, we had a nice long chat. You know, he's so charming. You know, of all the boys that you brought to our house, he's the only one that I had any use for.
Mother, now come on, drink your coffee. Ralph, would you like some?
What's the matter with him?
Nothing's the matter with him, Mother. Oh, Ralph has got tickets for a Broadway show tonight. He's going with Ed Norton.
Ed Norton. Doesn't he know he's got a wife?
Mother, Ralph asked me to go with him first. But I couldn't because you were coming over to spend the evening. Anyway, it's a wonderful show. It's called Murder Strikes Out.
Oh, that. Oh, I had a neighbor, Mrs. Finley. She thought she didn't think much of it.
Really? It was supposed to be such a big hit. The paper said it's a very exciting mystery.
Oh, the papers had just a lot of publicity. All that to do about chills and suspense. And that nonsense about don't tell your friends the surprise ending. Well, it was no surprise to Mrs. Finley. She said she knew all the time that it wasn't the uncle who committed the murder. It was the
You are a blabbermouth!
Well, I've had enough. I'm going home. Home.
I've had just as much of this as I can stand too, Ralph.
Doesn't change my mind. Doesn't change my mind.
Ralph Crampton. To the moon, Alice. To the moon.
So, it illustrates it in humorous fashion the importance sometimes of keeping secrets, which is related to what we're going to talk about today. So, let's talk about confidentiality. We'll talk a little bit about confidentiality and the underlying, doctrinal basis in the first hour, and then in the second hour we'll talk about a case. What's that? I wonder if that's the same thing. Yeah, it is. Okay, so let's talk about the relationship between confidentiality and privacy. In some ways, they're two sides of the same coin. When one uses the term privacy, it's used to refer to different entities. Okay, so when you think of privacy, if you think of privacy as sort of a bundle of rights, privacy can refer to, for example, the right to be let alone. And in fact, that's the language that's used in the Florida Constitution, the right to be let alone. Privacy is also sometimes used to refer to liberty to act in personal matters, and include, for example, the way the Supreme Court first used the term in relation to the abortion decision. But it also, and for our purposes today, this is what we're going to focus on, it also is sometimes used to refer to the protection of personal information. And that is the sense of privacy that's related to confidentiality, which is what we're going to talk about today. And one can say that an individual has privacy in a situation with regard to others if and only if, in that situation, the individual is normatively protected from intrusion, interference, or information accessed by others. Normatively means that others should not do it. Okay? They ought not to do that. So we're talking about information access today. That's what we're interested in. Confidentiality is basically the duty to protect that information from the provider's perspective. So if you want to think or restate the relationship, or if you want to think about the relationship between informed consent and confidentiality, which actually we haven't talked about informed consent yet, but this is sort of like a foreshadowing of what we're going to talk about. What you'll see is that there is a relationship between informed consent and confidentiality. Sometimes one of the things that you have to tell the patient as part of eliciting adequate informed consent is that something that he or she tells you you might not be able to keep that information in confidence. So this is a quote: doctors should make sure that their patients are informed about what kinds of information they do and do not regard as private, and under what conditions and to whom they will disclose the information. So for example, if somebody tells you that they are thinking about hurting somebody else, okay, that's not the kind of information that you would keep confidential. And there may be times that you need to warn people that if you tell me such and such, I'm not going to be able to keep that confidence as part of adequate informed consent. Okay, so let's talk about that's confidentiality, privacy. Let's talk about confidential communications. So confidential communications are statements that are made under circumstances that show that the person who's making the statement intends the statement to be heard only by the listener or the listeners. Okay, so examples of confidential communications are communications that take place between a doctor and a patient, between an attorney and a client, between a husband and a wife, and of course between a confessor and a penitent, so the secrets of the confessional. Now remember, not every conversation between a doctor and a patient is confidential. If you say something to the patient in the middle of the waiting room, that's not a confidential, or the patient says something to you in the middle of the waiting room, that's not a confidential communication. Okay? But if the patient says something to you under circumstances that suggest that he wants you to hold that information in confidence, that's a confidential communication. And from a legal standpoint, the law protects those statements, those confidential statements, from forced disclosure on the witness stand. So you can't force somebody to disclose the content of that statement on the witness stand. And that is waivable at the option of the patient or the client or the penitent, but not waivable by the doctor, lawyer, or priest. So that they can't waive that confidentiality. Only the person who made the confidential statement. All right, let's talk about where does confidentiality come from? Is this like a new thing? Is this a modern invention? You know, it appeared when they enacted HIPAA. And the answer is no. It's been around forever. It's a foundational principle in medical ethics. And if you look at the text of the Hippocratic Oath, this is one of the lines from the Hippocratic Oath, quote, "What I may see or hear in the course of the treatment or even outside of the treatment in regard to the life of men, which on no account one must spread abroad, I will keep to myself." That is an expression of the doctrine of confidentiality, duty of confidentiality. Pretty clear there. More recent ethical pronouncements, ethical codes also contain expressions of the duty of confidentiality. So, for example, the AMA Principles of Medical Ethics says, quote, "A physician shall safeguard patient confidences within the constraints of the law." Okay, so this is a little bit weaker than it was here. Here there's a legal out. There wasn't a legal out in the Hippocratic Oath. There is here. And if you look in the AA policy, their expression of their ethical policy, you'll find a similar thing in their ethical guidelines. There's similar reference to the need to maintain patient confidentiality. All right, so we know what confidentiality is. We know how it relates to privacy. We know that it's been around forever. Now the question is, why does it exist? Why do we have a doctrine of confidentiality? And there's a couple of reasons why we have a doctrine of confidentiality. And you can divide the reasons into utilitarian and non-utilitarian reasons. So the utilitarian reasons, first of all, as you might imagine, it encourages people to speak frankly to their doctor, their lawyer, their priest, when otherwise they might avoid speaking frankly out of shame, out of concern that it's going to find its way into public. Suppose there was no doctrine of confidentiality and somebody comes to me with a sexually transmitted disease and there's nothing to prevent me from sharing that information with everybody in my community. Well, then it's less likely that patients are going to come to see me because they might be more worried about their reputation being damaged than the consequences of just an untreated sexually transmitted disease. A second utilitarian reason is that it benefits not only the sick, but it benefits the well, all of us, because someday we might be sick. And so it's nice to know that if that comes to pass, that we too will benefit from the doctrine of confidentiality, and it benefits the public health as a whole because, again, to use the sexually transmitted disease example, you don't have all these cases of untreated sexually transmitted disease going around infecting the rest of the populace. So those are some just straightforward utilitarian reasons for the doctrine of confidentiality, at least in the context of medicine. But there's other reasons, policy reasons, that underlie the doctrine of confidentiality. So, for example, Cicella Bach has argued that the doctrine of confidentiality furthers the interest in autonomy over personal information. So it gives the individual control over his or her own personal information. That secondly, it fosters relational intimacy through the sharing of secrets. So when I share a secret with somebody else, that is a positive thing for my relationship with that other person. It might bring me closer to my physician, or closer to my lawyer, or closer to my confessor. And then finally, especially in cases such as, for example, the Hippocratic Oath, there's a special obligation that arises from the fact that we've promised to keep secrets. Okay? So in other words, this reason is related to the fact that the Hippocratic Oath says, I'm going to keep those secrets. If you make a promise to keep those secrets, then you have a moral obligation to keep those secrets. Any questions about what confidentiality is, how it relates to privacy, how it relates to the Hippocratic Oath, or why the doctrine exists?
So I have a question. So if a patient is speaking to a physician, does the physician say specifically, like, anything you share to me, I could potentially tell somebody else? You know, because I know there's like a situation where like a patient confessed that he had sexually molested his niece, but like it's not like the doctor went and told him like, oh, now because you shared this to me, I have. Well, before like he was about to confess, the doctor didn't like warn him or anything.
No, because he wasn't in a situation, in that situation, he wasn't like in a situation where he was in the process of getting like informed consent or something.
Okay.
Okay? So they were just talking and the patient spilled, basically spilled that information. But where it would come up would be, let's say you're recommending something to the patient, okay? You're recommending either a treatment or a diagnostic test, okay? Some diagnostic tests have implications for people. So, for example, HIV, okay? We'll talk about cases like that later on. Well, depending on the result, depending on the result of that test, of course, you need to report that result, right? It needs to be reported to the health department. But depending on what's going on with the patient's private life and stuff like that, one can argue about whether there's a duty to warn other people. And that would be a situation where if you're going to get a test, that you probably want to tell the patient, look, if this result comes back positive, I may or may not have to do this. And then he or she can make an informed decision about whether to consent to the test or not. Okay, so let's talk about the relationship of confidentiality and the moral rules. You can link the doctrine of confidentiality to numerous moral rules, okay? But you'll see that Gert links it most closely to one moral rule. Okay, that's what I want you to do. The doctrine of confidentiality is a particular moral rule. It's particular to certain professions like medicine and divinity and law. Okay, it's a particular moral rule. And how do you get a particular moral rule? You get a particular moral rule by combining a general moral rule with a cultural institution or practice. And this is Gert's explanation of how you come up with the doctrine of confidentiality. In medicine, the need for the physician to obtain information from the patient, in addition to the fact that people generally do not want information about themselves to be revealed, in conjunction with the general moral rule, there's something missing here, the general moral rule, not to cause pain, generates the medical ethical rule, do not breach confidentiality. Okay? So the need to get information, combined with the fact that people don't want information about themselves to be revealed, that causes suffering, okay? In conjunction with the general moral rule not to cause pain, generates the medical ethical rule, do not breach confidentiality. And remember, the attitude towards the rules is that everyone's supposed to obey the rules unless an impartial, rational person can advocate that violating that rule be publicly allowed. Anyone who violates the rule when no impartial person, rational person can advocate that such a violation be publicly allowed may be punished, and in the context of confidentiality, that punishment could take the form of a medical malpractice suit. It could take the form of an action against your license. So it could take multiple forms. Now, again, just as we said that there were no absolutes, there's no absolutes as they relate to any of the moral rules. Well, the same goes true to not just the general moral rules, but also the particular moral rules, and in this case, confidentiality. So there's no absolutes. The duty to maintain confidentiality is not an absolute, and sometimes the duty to breach confidentiality may be breached, and sometimes, in fact, perhaps it must be breached. Okay? And so the question is, when does the duty to maintain confidentiality give way to the countervailing duty to warn, or duty to protect other people? When does one yield and the other one takes over? Okay? And of course, that's going to be very dependent on the facts of the situation, whatever situation you're talking about. But you should realize that there are a number of factors that are universal that you have to consider in trying to decide whether to breach confidentiality or not. So these are all things that you have to think about when you're trying to decide whether to maintain confidentiality or breach confidentiality. So the first thing you have to think about is the severity of the potential harm to the third parties if I don't breach confidentiality. What's the severity of the potential harm to the third parties? Secondly, apart from the severity of the harm that they are likely to suffer, what about the probability of harm? Again, to the extent that the harm is very unlikely, that weighs against breaching confidentiality. As it becomes more likely, that weighs more in favor of breaching confidentiality. Third, the existence or non-existence of alternative means of protecting those at risk. So if there's third parties that are at risk and you can protect them in some way that doesn't involve breaching patient confidentiality, then maybe you ought to do that. There's other ways to do it. And we sort of alluded to that. Do you remember, does this remind you of anything that we talked about when we talked about professionalism? When we talked about the internal morality of medicine? So I just said, if you have third parties that are at risk and you can protect them by some means short of breaching confidentiality, then you ought to do that. Does that remind you of anything? Remember the three types of illegitimacy? Remember goal illegitimacy, means illegitimacy, and then means ends disconnect. And we said that you can't chop the guy's leg off when he has a superficial melanoma if a local excision is enough. Okay, so this is sort of this similar type thing, right? If there's something else you can do short of breaching confidentiality, then you want to do it. Fourth, the likelihood that breaching confidentiality will prevent the harm. As the likelihood goes up, then the argument in favor of breaching confidentiality goes up. And finally, the severity of harm to the patient. Now look, they're considering the severity of harm to the patient and also the severity of harm to the third parties. How embarrassing, well, how it doesn't have to be embarrassment, it could be some other harm that the patient suffers. How much will the patient be harmed from disclosing this information? Okay, is he going to lose his job? Is his marriage going to fall apart? Something else going to happen? All right, any questions about any of these?
So when it comes to that, then where do you draw the line? Or is it different case to case? Like,
Yeah,
do you protect the third party more or your patient?
Well, as I said, it's all going to be very fact. It's all going to be very fact. I think you should be figuring this out by now, right? There is no line.
Yeah.
Okay. It's going to be very fact intensive, and basically it's going to depend on the details of the situation that you're faced with, and the decision won't always be an easy one, okay? And it might be a decision where reasonable people disagree, right? And so if you have a situation where everybody agrees all rational people, impartial rational people, agree that confidentiality should be breached under these circumstances, then we would say that the breach of confidentiality was what? Strongly justified. If some people say yeah, you should breach, some people say no, then we'd say the breach was weakly justified. And if everybody says no, don't breach confidentiality under those circumstances, then we'd say that the breach is what? Unjustified. Okay? So those are all possibilities. Okay, so a lot of times people want to use this as an opportunity to talk about the elephant in the room, which is HIPAA. But we're not going to spend a lot of time talking about HIPAA. We'll talk about this. We'll talk about this later on, maybe in the context of the case. HIPAA is more important in terms of setting up procedures, procedural rights, and not so much in terms of creating substantive rights. So people always say, "Oh, HIPAA." But for our purposes today, let's focus on the stuff that we've talked about. We'll allude to this later on. Okay, so where do legal rights to privacy and confidentiality, apart from HIPAA, where do they come from? And again, those rights are mostly procedural. But where do they come from? Well, some of the rights to privacy derive from the federal and the state constitutions. We're not going to. If I don't talk about a particular case unless it's mentioned in the book, then you don't need to worry about what that case. You don't have to look it up. Okay. But if it's mentioned in the book, then you should be familiar with it. Okay. Sometimes federal and state statutes, federal statute including HIPAA, set up requirements in terms of privacy or create privacy rights, whether procedural or substantive. And then the common law, which means the judge-made law, cases that are decided by judges, is also a source of privacy rights. So let's talk first about some of the statutory protections of confidentiality. Statutory protections means protections of confidentiality that are created by state statutes or state laws that are enacted by state legislatures. So for example, many state licensure laws provide that breach of patient confidence constitutes unprofessional conduct. So if you get your PA license in Florida and you breach confidentiality, unjustified breach of confidentiality, you can be subjected to disciplinary action or even license revocation. Okay. You should be aware, depending on where you're going to practice, you should be familiar with the laws of the state that you're practicing in, or you should have access to an attorney who is, because sometimes there are disease-specific statutes that create confidentiality duties. There may be special duties created by statutes for certain diseases. So HIV, for example, sort of enjoys the status of super confidentiality. Okay, HIV-related information enjoys protection that regular healthcare information doesn't enjoy. You have to be aware of that, depending on the state you practice in. And then federal law imposes certain confidentiality requirements on the records of patients who are enrolled in federally funded drug and alcohol treatment programs. So if you're involved with them, you may have to be aware of those specific confidentiality requirements. What about the common law, which is the cases, the judge decided cases? This is a separate source of privacy protections. So most states provide for a private cause of action against physicians who impermissibly disclose confidential information, which means that a patient can sue you. You impermissibly breach a patient confidentiality. Again, the state can come after your license. Patient can come after you for money. Okay? What are they going to sue you for? It depends on what state you're in. In some states, they sue you for breach of contract, sort of this implied promise to maintain confidentiality. Okay? In some states, they'll sue you for medical malpractice. In some states, they'll sue you for breach of a fiduciary duty. In some states, they'll sue you for fraud or misrepresentation. The only reason it matters is that you wouldn't think it matters, right? If you sued, you're sued. You would think it, what difference does it make? But it does make a difference because from a technical standpoint, in some states, the statute of limitations is different for medical malpractice than it is for breach of contract, and so it might be impossible for them to sue you under one or the other, depending on what the statute of limitations is. So it doesn't matter until you get sued, and then all of a sudden it does matter because it has consequences for you. The important thing to take away is that there's a number of different doctrinal bases that patients can come after you for a breach of confidentiality, depending on what state you're in. Okay? Any questions about this? Yeah.
You've talked a lot about protecting confidentiality. Is there also lots of legal basis for when it's appropriate to breach that confidentiality?
Well, that's what we're talking about that now. In terms of, when you say legal basis,
Yeah, like
we're going to talk about
child
some,
abuse.
we're going to talk about some cases
Okay.
and some grounds for doing that. Okay, so this is to illustrate again the fact that just as there's concerns about confidentiality, on the other side of the coin, there's concerns about protecting third parties and a duty. There might be a countervailing duty to warn. So the limits of confidentiality refers to the duty to protect third parties. The duty to protect third parties could come from a couple of different places, okay? You could have a duty to report that's created by statute, okay, and we'll talk about that. You can also have a common law duty to protect third parties. So again, just as the protections of confidentiality relate to state statutes and to state case law, same thing with the duty to breach confidentiality. You can trace those to their roots in statute and case law. Okay, so let's talk about some of the statutory duties to report, when you have to report, when you have to breach confidentiality, okay? So some of the oldest involve the reporting of communicable diseases to the public health authorities, okay? So for example, AIDS and HIV infection has to be reported to the health department. It has to be reported by the physician who orders the test and receives the result of the test. And there's actually redundancy or duplication of effort. The lab that performs the test also has to report that to the state public health authorities. Also, child abuse and elder abuse must be reported. Uncontrolled epilepsy among licensed drivers has to be reported to the DMV, to the appropriate state authorities. Yeah.
I'm just kind of curious, how many people do you have to, okay, so say I have a patient and I find that I do HIV testing positive. How many people do you have to tell? Do you just call a certain?
You have to tell them, you have to report it to the public, the Department of Public Health Agency of the state of Florida. Yeah, it's going to be different in different states. That'll be the topic of one of the things we're going to talk about in the next hour. But what we're talking about here is the duty to report it to the state public health authorities. What you're asking is an interesting question, which is, for us to say that the law requires that you must report, let's say, an HIV positive test to the Department of Public Health, that says, okay, I must do that. If I don't do it, I'm in trouble. But if I do it, have I done enough? Or do I have to do something else? And so the answer is going to be, it depends on what state you're in. All right? What you see that all of these examples share in common is that the basis for having the rule in place that you have to report it is to protect identified individuals or the public, especially identified individuals who can't protect themselves otherwise, right? So children are vulnerable, elders are vulnerable, the general public is vulnerable to HIV positive persons who would otherwise prey on them without disclosing their status. Again, the idea is to protect individuals. Everybody see that? Yeah.
So what if you suspect someone has a communicable disease, but they deny being tested for?
Okay. What if you do? What are you asking me? What should you do?
Well, I'm saying they've got the right to deny being tested, but then again, you have this like obligation to the public.
Yeah, and it depends on the nature of the question you're asking. If you're asking a legal question, that's one thing. If you're asking an ethical question, moral question, is another one. And the legal question is going to depend on the state that you're in. Okay, and so we'll see that in the second hour when we actually talk about a case. We'll talk about a specific case. And again, more important than the actual specific case is that you'll see how these kind of cases are sort of approached. Okay? Another example of mandatory reporting, it's also statutory, is the fact that you have to report knife and gunshot wounds. The ER must mandatorily report these. And again, what's interesting about this, though, is that the policy concern that underlies this rule is not the same as the one that underlies the mandatory reporting of HIV or untreated, uncontrolled epilepsy or child and elder abuse. Here, the reason that they have this rule in place is so that they can apprehend wrongdoers. They want to get the person who was involved in the crime. Now, you might ask yourself, okay, why the reason that we breach confidentiality here, that we breach confidentiality here. The reason that we breach confidentiality here is that we have these people that are at risk that can't protect themselves. Here, the concern is that the instrumental purpose of protecting confidentiality is less likely to be frustrated by breach, since victims are highly likely to seek treatment anyway. So we always worry about breaching confidentiality, because if you go back to when we talked about the rationale that underlies confidentiality, we said that if we have a policy in place that protects this information, people are more likely to share the information with us, because they're not afraid it's going to find its way into the hands of people who are going to do them harm. So here you might say, well, if you disclose this information, if you have a mandatory reporting rule, and you say that knife wounds and gunshot wounds have to be reported to the police, doesn't that make it less likely that people who are shot and stabbed are going to seek help, seek help in the emergency room? And the answer that's been suggested is that, well, not really, because usually people who are shot and stabbed have to seek help. It's not the kind of thing, well, maybe I should, see how this goes before I seek medical attention. So there's less concern in this situation about breaching confidentiality, because the thinking is it's not going to dissuade people from getting health care. Yeah.
Do you also have to report it as self-inflicted? Let's say someone was cleaning a gun, or they walked with a knife and fell in, or.
I think you do. I don't know if anybody. I actually one of my brother's friends, actually, that happened to him. He was cleaning his gun, and the gun went off, and he shot himself in the hand. And I think you do have to report it, because I remember hearing the story, and I remember that the police were involved, and they were asking his wife all kinds of questions. Like, did he really shoot himself in the hand? And, I think they might have suspected her.
I was going to say, I think it's required just because it's not the medical professional's decision to make that judgment call, no matter what you're told.
Yeah. So, but I mean, the system is not perfect. I mean, I guess somebody could come in with a knife wound and say that it wasn't the knife wound. They could say it was something else,
Running with scissors.
I cut my hand washing glasses, washing the glass or something. So, but anyway. Okay, so that's statutory. Any questions about any of the statutory examples? These are examples that derive from statute of the need to report. There's also common law duties to warn third parties or protect third parties or to report, okay? And the legal duty to protect third parties may arise through cases where the patient's condition poses a significant danger to others. So historically, for example, there were, this applied to contagious diseases, okay? So patients, providers would have to report that. Patients could be maybe quarantined or treated against their wishes. Violent psychiatric patients is another one where that has to be reported. And we'll talk about some actual cases in this regard. And then, as we alluded to before, persons with medically related driving impairments. That's also a situation where there might be a common law duty to protect third parties. And so what that means, if there's a common law duty to protect third parties, is that if you're negligent and if you fail to live up to your duty in one of these areas, and that patient of yours who you have failed to control, okay, harms somebody else, that you might be held liable to that third party for the harm that they suffered. Physicians may be liable for harm to third parties where three conditions are met. Now, you're not absolutely liable. In other words, you're not strictly liable, okay? Only if you're negligent, okay? So you're liable if, first of all, there is a known or reasonably foreseeable hazard arising in some way from the physician's patient. So if your patient has a seizure out of the blue and has not had a seizure before, and they kill somebody, that's not your fault, okay? Or if they've never had any kind of psychiatric illness before, or any tendency to violence, and they kill somebody, that's not your fault, okay? Or if they contract a contagious and communicable disease that you haven't seen them for a while, you didn't know that they had it, that's not your fault either. Secondly, there has to be foreseeable, though not necessarily individually identifiable third parties. All right, what's the difference between a foreseeable third party and an individually identifiable third party? Anybody?
Foreseeable is just any person, someone other than you and the patient, and identifiable is, you can say, a name or a position.
Yeah, I think that's right. So, for example, if I have a patient that has that's married, and I know he's married, and he's got a sexually transmissible disease, one of the people that he could harm is his wife, and we would say that his wife is identifiable. It's Mrs. STD, okay? But if he's not married, but we just know that he's sort of sexually active and promiscuous, then the third parties, the foreseeable third parties, are the people that he's going to be sleeping with, the group of people that he's going to be sleeping with. I don't have to be able to identify them, okay? But if I know that he's, let's say, a heterosexual male, we say, well, it's heterosexual women, okay, in the area, okay? And then the third thing that has to be true is that the provider fails to take a reasonable course of protective action. So the important thing to take away from this is that you don't have to succeed at preventing the patient from hurting other people. You just have to behave reasonably. Your attempt to protect those third parties has to be a reasonable attempt. It has to be what reasonable doctors or physician assistants would do under the circumstances to protect third parties.
Is that just as simple as you record or you write your notes that you've educated the patient that you had an STD and that having sexual contact with other people?
It might be. That might be enough. It might not be. That's a question of fact. Whether something is, now what we're talking about here, as we haven't talked about it yet, but we will talk about it in the second half of the course, is medical malpractice. And what we're talking about here is what's referred to as the standard of care. And the standard of care is a question of fact. It's a question of fact to the jury most of the time. All right, so it may or may not be reasonable. Now, sometimes the standard of care can be established by law, okay, and the law sometimes can give you an answer to that question, whether that's sufficient or not. We'll see that in some of the cases that we're going to talk about now. Okay, so let's talk about some cases that illustrate the duty to protect third parties in action. Okay, that duty in action. Okay, the first one is Tarasov. So in Tarasov, this was a case from, the events happened in 69 and the early 70s. The case was from 1976. A young man named Podar, P-O-D-D-A-R was his last name. He tells his University of California psychologist, Dr. Moore, that he intends to kill a young lady named Tatiana Tarasov. So Dr. Moore thinks that he actually might try that, and so he attempts to have him committed for treatment. But for reasons that we don't know, the campus police released him because he appeared rational. So Dr. Moore's superior, Dr. Powelson, finds out what happened, and he directs Dr. Moore to make no further efforts to detain Mr. Podar, and he directs him to destroy his notes that said anything about the guy's dangerousness. So Tatiana Tarasov was never warned that this crazy person was out to kill her, and she was out of the country in Brazil, and she comes back to the country, and when she comes back, Podar, who had, perhaps not coincidentally, moved in with her brother, kills her. So there was obviously a criminal prosecution of Podar, and the family brings a liability action against the University of California, alleging a failure to warn. The legal question was, did they owe a duty to warn? The court decided that, in fact, they did. See if I can find a quote here. This is a quote of the court. Under the common law, as a general rule, one person owed no duty to control the conduct of another, nor to warn those endangered by such conduct. However, the courts have noted exceptions to this rule. In two classes of cases, the courts have imposed the duty of care. One, cases in which the defendant stands in some special relationship to either the person whose conduct needs to be controlled or in a relationship to the foreseeable victim. And two, cases in which the defendant has engaged in some affirmative action to control the anticipated dangerous conduct or protect the prospective victim. Both exceptions apply to the facts of the case. What you will see is that when we talk about medical malpractice, is that there's this thing called the no-duty rule, which basically says that under Anglo-American law, a person doesn't have to act legally to protect somebody else. There's no legal duty to act affirmatively to help other people, unless there's an exception that applies. And so one exception is a special relationship, so for example, doctor-patient relationship. But of course, Dr. Moore didn't have a doctor-patient relationship with Tatiana Tarasov. He had it with Podar. And the court sort of stretched things and said, well, if you have a relationship with the crazy patient, that creates a duty to the third party that runs through the crazy patient. A little bit creative, but that was one way they got to their holding. The other way is they said, you tried to help her. You tried to lock him up, and your attempt was not successful. And so an undertaking is another exception. When you undertake, once you undertake to do something, you have to act reasonably. And so they were sort of implying that he didn't act reasonably. The problem is, as you'll see when we get to medical malpractice, is that it's not enough that you just attempt to do something and not succeed. You have to leave, in order to satisfy the legal burden, you have to leave the person worse off than they were when you found them. And that's not clearly the case here. So anyway, Tatiana, the Tarasov case stands for the idea that if you have a patient, you have a patient who is a danger to third parties because of their psychiatric condition, that the healthcare provider owes or may owe a duty to protect or warn those third parties, okay, those other individuals. Now that's a California case. That's the majority rule in the United States, but it's not unanimous. And for example, if you look at Texas, this case here, Thapar v. Zazulka, and this is a newer case from the turn of the century. They said no duty to warn under similar circumstances. Okay, but the majority rule is the Tarasov rule, which would impose a duty on the provider to warn. Okay, any questions about Tarasov?
So who is found in violation here? Dr. Moore, who attempted to, or University of California?
Okay, the University of California was the defendant because of a doctrine called vicarious liability. Vicarious liability. The university is going to be liable for the negligence of its employees, and probably Moore and Powelson were both employees of the university. The university has deep pockets, so they're going to go after the university. Okay. Now, if you're asking whether Powelson and Moore would also be directly liable, would be individually liable, Powelson almost certainly yes, because of what he did.
He's the one who said, don't
destroy the records and don't pursue it anymore. Moore, that's a tougher question. You know, the question is, did he behave reasonably under the circumstances? Or did the fact that he was told by his chair not to make further efforts, did that sort of break the causal link for him? Okay? I don't know. It's a tougher call. Okay, the second case, Bradshaw v. Daniel. This was a 1993 case. Okay, and in this case, this is a fascinating case. We have a patient named Elmer Johns, who gets admitted to the hospital in 1986 with symptoms of Rocky Mountain spotted fever. And Dr. Daniel starts him on treatment for Rocky Mountain spotted fever. So he either makes the diagnosis or suspects the diagnosis, and based on that, initiates treatment. However, in spite of appropriate treatment for Rocky Mountain spotted fever, the patient deteriorates and dies. Although the doctor speaks with Mr. Johns' wife during his course of treatment, he never told her about Rocky Mountain spotted fever or that her husband might have it. Okay. Now, this case would not be interesting if Rocky Mountain spotted fever was transmissible from person to person. If it was a contagious disease, or communicable that way, then this case is not interesting. okay? She's suing him and saying, you should have told me that he had a communicable contagious disease. If you had told me, I would have gotten treatment too. She didn't get treatment. So a week after he dies, she gets admitted with similar symptoms, and she's treated for Rocky Mountain spotted fever by another doctor because he is not her doctor. Okay, Dr. Daniel is not Genevieve's doctor, and she dies. Again, this is a straightforward case if Rocky Mountain spotted fever is transmissible from person to person, like the flu, but it's not. It doesn't spread that way. And so she sues him. Go ahead.
Isn't she dead?
Well, the state sues. The estate sues. And so she sues him, and this is what Dr. Daniel, how he defends himself. He argues, first of all, that he owed the patient's wife no legal duty because she's not his patient. That's a good point. Secondly, he says, while there is precedent for holding doctors liable for injuries to the non-patients caused by contagious diseases, Dr. Daniel points out that Rocky Mountain spotted fever is not a contagious disease because it's not transmitted from person to person. Therefore, he says, unlike the Tarasov case, my patient was not the danger to his wife that Podar was to Tatiana Tarasov. And this is what the court said. The court says, family members of patients suffering from Rocky Mountain spotted fever are at risk of contracting the disease due to a phenomenon called clustering, which is related to the activity of infected ticks who transmit the disease to humans. We therefore conclude that the existence of the physician-patient relationship is sufficient to impose upon a physician an affirmative duty to warn identifiable third persons in the patient's immediate family against foreseeable risks emanating from a patient's illness. Accordingly, we hold that the defendant physician had a duty to warn his patient's wife of the risk to her of contracting Rocky Mountain spotted fever when he knew or in the exercise of reasonable care should have known that his patient was suffering from the disease. So they said it doesn't matter that the disease, that the danger didn't emanate from Elmer Johns, from the Dr. Daniel's patient. Okay? It doesn't matter. Yeah.
With that, to me it sounds like we almost have to warn everything because every disease possible. You can get TB from a nail, so the nail's in proximity to the family, so you have to tell the family like this type of nail, like, you know what I mean? Like, what disease would cluster? If someone has it, obviously there's something there that could give it to someone here.
Well, I mean, diseases they're talking about the fact that people that are in the same family or in the same social circle could all be exposed to the tick because they do things together, right? They could be exposed to the tick or the ticks. But yeah, you're right. Diseases can cluster for different reasons. They can cluster for reasons that have to do like this one, or they can cluster for reasons that have to do with genetics. And so this case looks like it's opening a door, right? It looks like it's making the duty a lot broader than it was before this case. This is a big case. Okay, this is quite a difference from Tarasov. Okay, so Tarasov took one step that enlarged the duty. Okay, and now this court is taking still yet another step. Okay, let's take a break here. Let's come back in 5 minutes. So 10 after we'll come back. We'll do 2 more cases, and then we'll do a discussion of a case.